You know, there are certain questions that sit in this weird, dark corner of the American psyche. We don't like to talk about them at dinner parties, and we definitely don't bring them up at the airport security checkpoint. But late at night, maybe after watching a movie or reading a particularly tense news story, the thought creeps in. It's the hypothetical that no one ever wants to actually face. But in a country where the Second Amendment and policing are constant, heated topics, it's the question that lingers in the back of a lot of minds. It's the scenario that sounds like the plot of an action movie, but when you strip away the Hollywood explosions and the one-liners, it becomes a terrifying legal and moral maze. So, let's just put it out there, because we need to talk about it. If you are a law-abiding citizen, legally armed, and you find yourself in the unfathomable position where a law enforcement officer is using deadly force against you, can you legally shoot back? I want you to really think about that for a second. Put yourself in those shoes. What would you do? How would you react? And more importantly, what do you think the law actually says about that split-second decision? Don't just let that question float away. I want you to actually answer it for yourself, right now in your head. And then, I want you to scroll down to the comments section and write it out. Have you ever considered this? Do you have a plan? Do you think the law is on your side in that moment? Or are you immediately crossing a line that you can never uncross? I'm genuinely curious where people's instincts go on this one, because the reality is so much more complicated than most people realize. Drop your thoughts in the comments, and let's see if anyone's initial gut feeling actually matches up with what the statutes, the case law, and the sheer chaos of a real-world confrontation would dictate. And here's the thing. I'm not asking this to be provocative for the sake of it. I'm asking because the answer touches on the very core of how we define self-defense, authority, and the rule of law in this country. It's a question that separates the armchair commandos from the people who have actually studied the weight of a badge and the even heavier weight of a bullet's legal aftermath. Stick with me, because we are going to peel this onion all the way down. We're going to look at the constitutional foundations, the state laws, the psychological aspects, and the grim, gritty reality of what happens to your life if you survive that encounter. By the time we're done, you're going to understand not just the letter of the law, but the spirit of it, and why the smartest fight is almost always the one you manage to avoid entirely. Let's start by dismantling the most fundamental assumption people have. In the American legal system, cops are not just regular people with a cooler uniform. When that officer pins on their badge in the morning, they are stepping into a specific legal role. They become the state. They are the embodiment of the government's authority to enforce the law. And that distinction is everything. When a private citizen threatens you, you are facing another individual. When a cop threatens you, you are facing the full weight of the legal system, and that system has built-in rules that specifically protect its agents while they are doing their jobs. It's not a fair fight legally, and it was never designed to be. The core of this entire discussion revolves around the legal concept of justification. In criminal law, justification is what takes an act that would normally be a crime, like shooting someone, and makes it lawful. Self-defense is the classic example. If someone is about to kill you and you use force to stop them, you are justified. The law doesn't want you to be a victim. But when the person using force against you is a police officer, the justification analysis does a complete 180-degree flip. The officer's use of force is presumed to be lawful because they are acting under the color of law. They have a legal duty to enforce the law, and sometimes that requires force. So, for you to be justified in using force against them, you have to overcome that massive presumption. You have to prove that the officer was not acting lawfully, but was instead acting outside their authority. This brings us to the famous, or infamous, standard established by the Supreme Court in the 1985 case, Tennessee versus Garner. You've probably heard of it, even if you don't know the name. This is the case that says a police officer can use deadly force to prevent the escape of a fleeing suspect only if the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. That's the textbook definition. But the practical application is where things get messy. It means that if an officer shoots at you because they genuinely, even if mistakenly, believe you are about to kill someone, or that you are an immediate deadly threat, that shooting is legally justified. It doesn't matter if they were wrong, as long as their belief was reasonable under the circumstances. So let's plug you into that equation. The officer is shooting at you. For you to have a legal right to shoot back, you would have to be able to articulate in a courtroom, in front of a jury, after being grilled by a prosecutor, that you knew with absolute certainty in that split second that the officer was not acting under a reasonable, even if mistaken, belief. You would have to prove that the officer was acting with malice, or was so far outside the bounds of their training that they had become, in the eyes of the law, a rogue actor, no different from a common criminal. That is a burden of proof that is nearly impossible to meet in the moment, and incredibly difficult to prove after the fact. And this is where I have to stop and give you a very real, very uncomfortable warning. The legal system is not designed to give the benefit of the doubt to a civilian who shoots a cop. It's just not. From the moment that first round leaves your barrel, you are the bad guy in the story. The entire machinery of the state, from the local police department to the district attorney's office to the state police, will mobilize against you. You will not be treated as a self-defense shooter. You will be treated as a cop killer or an attempted cop killer. The presumption of innocence that we all hold dear evaporates in the heat of that moment because you have challenged the ultimate authority. You have committed the one act that the system is almost biologically programmed to punish without mercy. Think about the practical realities for a second, beyond the legal jargon. We're not in a vacuum here. If a cop is shooting at you, it's not just that one officer. It's his partner. It's the two guys in the car that just pulled up behind him. It's the three cars that are responding to the officer needs assistance call that went out over the radio 30 seconds after the first shot was fired. In a real-world scenario, if you shoot back at a cop, you are not engaging in a duel. You are lighting yourself up like a beacon for every officer within a 5-mile radius. They are coming, and they are coming with the mindset that one of their own is under fire. The level of force that will be brought to bear on you will be overwhelming. It will be absolute. You will be surrounded, outgunned, and the concept of a fair fight will be laughable. But let's push past the tactical suicide of it and stay on the legal hook, because that's where the real trap lies. There is a legal doctrine you need to understand, and it's one of the most misunderstood concepts in American law: the reasonableness standard. It governs everything cops do, especially when it comes to force. The courts don't look at these situations with the perfect 20/20 vision of hindsight. They look at it from the perspective of a reasonable officer on the scene who is often forced to make split-second decisions in tense, uncertain, and rapidly evolving circumstances. That's the Graham v. Garner standard, another Supreme Court case from 1989 that is the Bible for use of force litigation. What that means for you is this: even if the officer was completely wrong about you, even if you were innocent, even if you were just reaching for your wallet and they thought you were reaching for a gun, if a reasonable officer in that same situation could have made the same mistake, their use of force is lawful. The bar for what constitutes an unreasonable mistake by a cop is set astronomically high. So, for you to be justified in shooting back, you would have to know in that moment not just that the officer was wrong, but that no reasonable officer could possibly have believed they were right. You would have to be certain that the officer was acting in bad faith, that they were essentially trying to execute you for no reason. And how exactly do you determine that while someone is shooting at you? You can't. It's an impossible calculation. The human brain, under that kind of stress, is not capable of nuanced legal analysis. It's operating on pure survival instinct. Your amygdala has taken over, and your prefrontal cortex, the part of your brain that does logical thinking, has essentially shut down. You are in fight, flight, or freeze. The idea that you could calmly assess the officer's state of mind and determine whether their actions meet the legal definition of objectively reasonable is a fantasy. It's a legal argument that gets made by lawyers months later in a quiet courtroom with diagrams and witness testimony. It is not a decision you can make in the street. This brings us to a crucial point about how travelers and armed citizens often misunderstand the role of police. We tend to view them, sometimes subconsciously, as just another person, just another potential threat that we have the right to deal with. But you cannot view them that way. They are not just another person. They are the gatekeepers of the social contract. When you interact with a police officer, you are interacting with the system itself. And the system has a very low tolerance for people who take its authority into their own hands. I want to tell you about a case that isn't famous, but it should be. It was a case out of a rural county, not a major metropolitan area. A guy was driving home late at night. He had a concealed carry permit. He got pulled over for a taillight out. The officer approached, and the driver, nervous, made a sudden movement to retrieve his registration from the glove box, where he also kept his firearm. The officer saw the gun, perceived an immediate threat, and fired. The driver, wounded, returned fire and hit the officer. He survived. The officer survived, and then the legal system went to work. The driver's defense was pure self-defense. He said he was terrified. He thought he was going to die, and he acted to preserve his own life. It sounds reasonable, right? That's the instinct we all have. But the prosecutor painted a different picture. They argued that the driver, by reaching suddenly into a glove box he knew contained a gun, in the presence of an officer who had just pulled him over, created the situation. They argued that the officer's reaction, while perhaps extreme, was a direct result of the driver's actions. The driver, they said, had a duty to de-escalate, a duty to comply, a duty to make his intentions known. By doing the opposite, he contributed to the chaos. The jury bought it. He was convicted of aggravated assault on a law enforcement officer and sentenced to 20 years. His life was over because he couldn't overcome the presumption that the officer was acting in good faith. That case illustrates a horrifying truth. You can be legally right and still be legally screwed. Even if you could somehow prove that the officer's initial shot was unjustified, you then have to deal with the fact that you shot a cop. The system will look at every single thing you did leading up to that moment. Did you comply with every order? Did you keep your hands visible? Did you do everything humanly possible to communicate that you were not a threat? If the answer to any of those questions is no, a prosecutor will use it to chip away at your self-defense claim. They will argue that you were the architect of your own misfortune. And this is where the conversation gets really dark, because we have to talk about the concept of color of law. An officer is always acting under the color of law as long as they are purporting to perform their official duties. Even if they are abusing their power, they are still, in a technical sense, acting under the color of law. It's a legal fiction that protects them. For an officer to lose that protection, they have to step so far outside their role that they are essentially on a frolic of their own, a personal vendetta completely unrelated to law enforcement. If an off-duty cop in plain clothes gets in a bar fight and shoots someone, that's not acting under color of law. That's just assault. But if that same off-duty cop sees you jaywalking, flashes a badge, and shoots you when you run, he's probably still acting under color of law because he was attempting to perform a law enforcement function, even if he did it in the most egregious way imaginable. So in the scenario where a uniformed on-duty officer is shooting at you, you are almost always facing someone acting under color of law. And that means you are not just defending yourself against a person, you are defending yourself against the state. And the state does not recognize your right to resist its authority, even if that authority is being exercised unlawfully. This is a key principle that goes back centuries in common law. The idea is that any resistance to a known officer, even if the arrest is unlawful, is itself a crime. The logic is that the proper place to challenge an unlawful arrest is in court, not on the street. You submit, and then you sue. Now, does that logic hold up when the officer is using deadly force? That's the million-dollar question, isn't it? Can the state really demand that you submit to being killed and then rely on your estate to sue for damages later? Legally, the answer is nuanced. Most states have laws that explicitly say you cannot resist an arrest, lawful or unlawful, with force. But those laws are generally aimed at situations involving handcuffing and booking, not being shot at. When it comes to deadly force, the common law principle of self-defense, the fundamental right to protect your own life, has to come into play. At some point, the state's interest in maintaining order has to yield to the individual's right to exist. But here's the catch. That point is not clearly defined. It's a gray area where lawyers make their livings. There is no statute that says, if a cop shoots at you unjustifiably, you may shoot back. It doesn't exist. Instead, you have to rely on general self-defense statutes, which typically require that you reasonably believe deadly force is necessary to prevent imminent death or great bodily harm to yourself or another. So you're back to that reasonableness standard. Is it reasonable to believe that a police officer whose job is to protect the public is about to unlawfully kill you? In the vast, vast majority of cases, the answer the law expects is no. It presumes the officer is acting lawfully until proven otherwise in a court of law. You are not the judge of that in the street. Let's shift gears for a moment and talk about the aftermath, because this is where the rubber really meets the road for anyone who travels or carries a firearm. If you survive this encounter, if you are somehow still breathing after trading fire with the police, you are entering a legal nightmare from which you will likely never fully awaken. You will be arrested, you will be charged, and the charges won't be simple assault. They will be attempted murder of a police officer, a crime that carries some of the harshest penalties in the book. In many states, it's a separate, aggravated offense with mandatory minimum sentences that can stretch into decades. Your bond hearing will be a spectacle. The prosecutor will paint you as a vigilante, a cop hater, a danger to society. The officer will be portrayed as a hero who was just doing his job, trying to go home to his family. The courtroom will be filled with police officers in uniform, a sea of blue staring at you, the person who shot one of their own. Do you think a jury of your peers is going to be impartial? They are human beings. They see the news. They feel the tension in the air. They know that if they acquit you, they are essentially saying it was okay to shoot a cop. That is an incredibly heavy burden for a juror to bear. And the cost. My God, the cost. Even if you have a good defense, even if you are ultimately acquitted, the legal fees will bankrupt you. You are looking at hundreds of thousands of dollars, easily. You will need expert witnesses, use of force experts, maybe psychologists, accident reconstructionists. You will need a legal team that specializes in this kind of defense, and they do not come cheap. You will lose your job, your savings, your house, your relationships. The stress of it will tear your family apart. Your name will be dragged through the mud in the local paper, on social media, on the evening news. You will be the person who shot a cop, regardless of the outcome. That label never washes off. So let's bring this back to the original question. Can you legally shoot back? In a purely theoretical academic sense, in a vacuum, the answer is yes. If an officer steps so far outside the bounds of lawful conduct that they become a criminal aggressor using unjustifiable deadly force against you, the fundamental right to self-defense could, in theory, be invoked. The law does not completely strip you of your humanity the second a badge comes into view. There is a line. If an officer, for example, walks into your home, announces they are going to kill you for no reason, and starts shooting, you are not required by law to be a passive victim. You have a right to defend your life. But here is the hard truth that I want you to take away from this. The law is not a video game. It is not a set of clear binary rules that guarantee a fair outcome. It is a human system, administered by humans, interpreted by humans, and judged by humans. And the human instinct to protect the police, to see them as the good guys, and to see anyone who raises a hand against them as the ultimate bad guy, is overwhelmingly powerful. In the real world, if you shoot a cop, you are fighting a battle you cannot win, you are fighting the system itself, and the system always wins. This is why the smartest, most experienced, most knowledgeable people I know in the world of self-defense and travel safety will tell you the same thing. Your goal, your absolute non-negotiable objective in any encounter with law enforcement is survival. And survival does not mean winning a gunfight. Survival means going home to your family. If that means taking a beating, you take the beating and sue later. If that means being wrongfully arrested, you go to jail and let your lawyer sort it out. If that means enduring humiliation and indignity, you endure it. Because the alternative, the path of resistance, leads to a place you do not want to go. There is a reason why the police academy spends so much time on communication and de-escalation. They are taught to control situations with their voice, their presence, their authority. And when that fails, they are taught to control it with overwhelming force. You cannot out-escalate the police. They have the numbers, they have the weapons, they have the radios, and they have the law. The moment you introduce a gun into the equation, you have just given them permission to use every tool in their arsenal against you. I've traveled all over this country, and I've seen people make terrible mistakes because they let their pride, their fear, or their anger get the better of them. They forget that the guy in the uniform is just a person who might be having a bad day, who might be scared, who might be prejudiced, who might be incompetent. And in that moment, they treat him like an adversary. They argue, they refuse, they make sudden movements. And it almost always ends badly. The key is to remember that you are not dealing with a person. You are dealing with a system. And you do not fight the system with a gun. You fight it with a lawyer, a camera, and a checkbook. So I'm going to leave you with that thought, and I want to circle all the way back to the question I asked at the beginning. What would you do? I've given you the legal framework, the practical realities, and the grim warnings. Now I want to hear from you. Do you think you could ever pull that trigger? Do you think the law would ever be on your side? Or have I convinced you that the only winning move is to not play the game at all? Head down to the comments. Let's get a real conversation going. Because this isn't just a hypothetical for a YouTube video. This is a question about the very nature of our rights and our relationship with the people who are sworn to protect us. It's a conversation we need to have honestly and openly, without the Hollywood gloss. I'll be reading the comments, and I'm genuinely interested to see where you all land on this, because in the end, it's not about being right. It's about being alive.